Let's take a moment and take stock of what we've covered in criminal homicide so far. We've discussed the concept of homicide, which is the actus reus for any criminal homicide charge. That is proving that by a voluntary affirmative act or the failure to act, defendant caused the death of the victim. In terms of criminal homicide, we explored murder 2, which is a homicide committed with malice. Malice is a man-endangering state of mind that is proven under one of 4 theories. Either the intent to kill that's not justified, excused, or mitigated, the intent to commit serious bodily harm, or killings done in an extremely reckless manner called depraved heart murder, and those killings that occur during inherently dangerous felonies not specifically listed in the Murder 1 statute. To date, we've only covered the intent to kill. We also discussed Murder 1 under a theory of premeditation. That is a mens rea that's added to the intent to kill and focuses on whether the actor reflects on his intent to kill. In that regard, we discussed 2 cases: Bingham, where defendant brought the victim down this lonely, isolated road, raped and strangled her, and Guthrie, who stabbed to death his co-worker. In Bingham, the court said that one has to consider all the facts to help prove whether defendant had the opportunity to deliberate and whether he did deliberate. In Bingham, that's why the majority rejected the idea that defendant had premeditated the strangling of the victim. He may have had opportunity, but not enough evidence to prove that he did. Guthrie, our dish towel snapping case, added to Bingham that intent to kill and premeditation are 2 distinct mental states. They're not synonymous. There's got to be proof of a separate step, not just the intent to kill, but separately the reflection on killing. Now I want to draw your attention to footnote 24 in the Guthrie case. It adds another important point in the analysis. Footnote 24 refers to a case out of California called People v. Anderson. It's a horribly brutal case involving a man who lived with a family and who stabbed the 10-year-old girl in that home more than 60 times. Out of this terrible case came some important legal principles, all pertaining to premeditation. The court explained additional ways to analyze the facts to decide whether a defendant has premeditated a killing. It's a 3-factor test that the Guthrie court approved and which can be helpful for us as well. The Anderson court said that premeditation can generally be proven through 3 main categories of facts: planning activities prior to killing that show the reflection on killing, a motive to kill, which comes from the prior relationship or behavior with the victim, and finally, if the way the victim was killed evidences a preconceived design to kill. These are factors, not elements, just ways to marshal the facts to see if premeditation happens. But they're very helpful in conjunction with the Bingham analysis. The California court noted that motive alone will never suffice for premeditation, nor should it. I could kill that guy is not premeditation. But generally, it's the combination of all the facts that make it work. Now that we've considered murder 2 with one of its theories, intent to kill, and its elevation to murder 1 under premeditation, I want you to tackle the following hypothetical. It's called the case of the angry employee, and it is an homage to the oldie but goodie movie, The Devil Wears Prada. Alas, in this hypothetical, the person playing Anne Hathaway, the beleaguered employee, kills the boss, Meryl Streep, the uncompromising and hellish boss. In your analysis, please incorporate the legal principles from the cases we've done, as well as the Anderson factors cited by the Guthrie court.